Hello and welcome to yet another episode of the In News series. My name is Pooja Dwivedi. Today we are going to discuss a very special and unique case. A case of a Muslim couple who belonged to Kerala. They were married approximately 3 decades ago, but now they have been registered afresh. Their marriage has been registered afresh under the Special Marriage Act. Now, Special Marriage Act is a refuge for those couples who belong to different religion or faith and they decide to get married under the civil laws and not the personal laws. But this couple was a Muslim couple. There was no interreligious marriage 3 decades ago. But now, why they have decided to get registered under the Special Marriage Act? This is really interesting. It has to do something with inheritance. So these are the many topics that we are going to discuss step by step from the perspective of GS Mains Paper 2nd and 4th as well as from the perspective of prelims as well. Special Marriage Act has been recently in the news a lot. First, because of Swara Bhaskar's marriage, and second, because of this particular news. So please go through it. Now, if we talk about the news, a Muslim couple in Kerala's Kasaragod district registered their marriage under the Special Marriage Act, and this has been done after approximately 3 decades. They were earlier married under the Sharia. Okay, so let us move ahead and talk about why is the couple registering their marriage afresh under SMA. This has been done to avoid their inheritance being split under the Sharia legal code, and also to ensure that only their 3 daughters can be the legal heirs as per the civil laws, because inheritance laws under Muslim laws are very different from what we observe under civil laws. This would not be possible according to Muslim inheritance law, and that is why it is being done. Now, if we talk about how do Muslim inheritance laws work, the inheritance for Muslims in India is governed by the Muslim Personal Law, that is Sharia Application Act of 1937, and the legislation that has codified Sharia recognizes 2 kinds of legal heirs. Now, this couple wants their inheritance to go to their 3 daughters and not anybody else. So, the 2 kinds of legal heirs are sharers and residuaries. Okay, remember that. Now, if we talk about a legal heir who gets a share in the inheritance are of 12 categories. First is the husband, second is the wife, third is the daughter, then daughter of a son or son's son or son's son, and so on. Then we have father, paternal grandfather, mother, grandmother on the male line. Then we have full sister, that means both the parents are the same for the children. Then we have consanguine sister. Consanguine sister is basically somebody who is related, sister who is related by kinship and not by adoption or marriage. Then we have uterine sister, that means same mother for all the daughters but different fathers, and uterine brother means same mother for the brothers, for the sons, but it could be from different fathers. So this is how inheritance work for one group. Then there are residuary heirs. Residuary heirs, by the name you can see, these are distant related people, aunts, uncles, nieces, nephews and other distant relatives, and the value of their share depends on several scenarios. For example, a wife can take 1/8 share of her husband's property upon his death if they have lineal descendants. Then we have, if she doesn't have lineal descendant with her husband, she takes 1/4 of the share. Then daughters cannot inherit more than half of what the sons inherit. The state of a Muslim can only pass to a Muslim which prejudices the wife or children following another religion. So this is very unsecular according to the General Act, the SMA. That is why the inheritance is shared. Inheritance has been done under the SMA by the current couple. Now, under Shariat law, only 1/3 of the estate can be willed in favor of anyone, and the remaining will still have to be divided as per the complex religious laws. Therefore, a Muslim couple has no way under the religious law to make someone their sole heirs, and this was the problem, and that is why the current couple have registered their marriage afresh under the SMA. Now, Shukkur and Sheena is the name of the husband and the wife we are talking about. They were first married in 1994 by a local Qazi. And Section 15 of the SMA allows for any marriage celebrated not according to the provisions of the Special Marriage Act. It can be registered under the Act. And this can happen when there are certain scenarios. A ceremony of marriage has been performed between the parties and they have been living together as husband and wife ever since. So this is applicable. Neither party has at the time of registration more than one living spouse. Neither party is an idiot or a lunatic at the same time of registration. The parties have completed the age of 21 years at the time of registration. The parties are not within the degree of prohibited relationship. Okay, so these are the criteria or check boxes. The procedure for registering an existing marriage, it would be the same as solemnizing a new marriage. Both the parties must have been residing within the district of the marriage officer for a period of not less than 30 days. Very important. Then a 30-day notice is given by the marriage officer for objection. This has been the most criticized part of SMA, as anybody who wants to, it can be done by anybody actually. So anybody who wants to, further, you can say, delay the process of marriage for a couple under the SMA, they can object. So this has been very contentious. So in the current situation, if we talk about SMA, the Indian Succession Act would apply and not the Shariat law. So many couples have took refuge under the Special Marriage Act to avoid religious law, and it is not new. For example, divorce was recognized only in exceptional circumstances among Christians. The Indian Divorce Act of 1869, it regulates the law which relates to the divorce for Christians, recognized adultery as the only ground for divorce till as recent as 2001, when the law was amended. So in 2001, the Indian Divorce Act 2001 was passed, which recognized the other grounds as well other than adultery. Till then, for many Christian couples who wanted divorce, they had to be registered under the Special Marriage Act, okay, and then move for divorce under the civil law. So these are the many aspects which we had to discuss from the perspective of your exam. I hope you understood it, and that's all for today. Thank you so much for watching.